This presentation will go through the appeals at the High Court that NMC Watch has tracked over the last few years. We will look at the recurrent themes where the regulator has been shown to have got process wrong and where the panels have erred in their decision making. And we'll look at how these themes are repeated throughout other appeals as the years have progressed. NMC Watch has been tracking all of the successful High Court appeals since 2009 to the present day, which is August 2026. We've been looking at the cases that have been taken to the High Court, either with union support or as registrants as litigants in person, and also we've looked at some of the challenges that the PSA have made via the High Court towards the NMC decision making. Through tracking these cases, we have seen consistent errors, excessive sanctions, and procedural failures, with High Court judges repeating the same themes with their outcomes when the registrant wins the appeal. Multiple High Court judgments have shown that the NMC fitness to practice process repeatedly fails on facts, evidence, reasoning, impairment, and sanction. These cases have found that panel findings have been quashed either in their entirety or in part, that sanctions have been reduced or replaced, and cases have in some cases been remitted to a new panel or overturned entirely. When registrants take the brave step to appeal their case in the High Court as litigants in person, they often will succeed. However, it is safer to try and do so with legal representation if they can afford it, and sometimes the unions will actually support these appeals. The High Court has been found a challenging but safe place for registrants to be able to act as litigants in person and challenge the decisions made of NMC panels. The courts have been found to frequently criticise the NMC's approach and are sympathetic towards the registrant when they try to plead their case without representation. From the cases we've reviewed, we can see that the judges have commented on the lack of pursuit of sanction down to public interest in a proportionate way, not giving enough weight to remediation, mitigation, and general proportionality, and generally overlooking evidence that the registrant presents to show that they have remediated. We have found at NMC Watch 56 cases that have won in the High Court, overturning the sanction put in place by the NMC panel. This is 56 cases since 2009 when we've been tracking them from. The most recent case was that of Mildred Wiley, a registered nurse with decades of experience. She and her husband managed nursing homes in Northern Ireland, and she was struck off the nursing register after a process that took over 6 years. The hearing itself took over 6 years. The referral had sat with the NMC for nearly 14 years. The High Court of Northern Ireland quashed the striking off order in its entirety and made many criticisms about both the NMC's case presentation, the legal assessor, and the way the panel made the decision. The judge said that the decision on disclosure was found to be fundamentally flawed. The case presenter misinterpreted the test of Ivey in measuring dishonesty, and the legal assessor did not correct that error. The legal assessor's approach was also criticised, as was the panel decision making. In the case of Davies versus the NMC, again in 2026, he challenged his strike-off order. He was a nurse with a 40-year career, 20 years of which were in ICU where the incidences occurred and where the allegations were raised. He acted as a litigant in person, and the strike-off order was set aside by the court. Mrs. Justice Collins, who we've seen in other appeals, stated, "I am, however, sufficiently clear that the manner in which the panel reached and/or explained its decision-making falls short of the standard of which justice should have achieved and which Mr. Davies was entitled to, particularly having regard to the panel's obligation in law to direct all of its evidentiary and fact-finding functions objectively towards the NMC's burden of proof, as to the balance of object probabilities, and to do so demonstrably. It's an interesting case, and one again that shows us that the NMC don't necessarily look at the aspects in the same way as the court do. It takes a brave registrant to challenge this in the High Court, and it's wonderful to see that the judges are actually pointing out the errors of the NMC's ways. However, it's disappointing to find that this happens, because we should be able to rely on the NMC to not repeat the mistakes of the past and to actually make sure that their systems are robust and accurate. In the case of Nourish versus NMC, the High Court held that the finding of dishonesty must be quashed, along with the resulting finding of impairment and the striking off order. The matter was sent back to a different constituted NMC panel to reconsider impairment and sanction. We've had communication with this registrant, and as of July, she was still waiting to hear when the hearing would be scheduled by the NMC. In November 2025, Green versus the NMC at the High Court. This was looked at by Justice Eyre and showed again repetition of the same errors by the NMC as with the previous High Court appeals. The nurse's appeal was allowed in part, with some findings not properly supported by the evidence and involving flawed reasoning, particularly in the treatment of hearsay. Because those charges had materially influenced the panel's decision on impairment and the 6-month suspension, the sanction was set aside, and again it was sent to a new panel to reconsider matters at a later date. We're unsure whether this has happened yet. In the case of Hannigan versus the NMC, November 2025, the High Court appeal was heard under the same judge as for Nourish v NMC, Justice Eyre. Justice Eyre stated to send the case back to a new hearing, but if the registrant was allowed to successfully apply for agreed removal from the register, that would be favourable over conducting a hearing. The registrant had previously applied for agreed removal before the original hearing, as she has no intention of returning to the profession and had sought an alternative career path, but this had been refused by the NMC. The NMC had refused agreed removal. This shows that the NMC should seriously consider AR as an alternative rather than costly hearings which are not either in the public interest or the registrants and are financially punitive for the registrant. It was argued by the registrant that to return to a new hearing would be difficult due to being unable to fund representation and the RCM potentially not being able to provide representation for her. She had employed a private legal representation for the purposes of appeal, but this was all that she could afford. She is still waiting for confirmation from the NMC if they will consider agreed removal. An NMC Watch last spoke to her in August and she is still waiting. Phillips v the NMC, October 2025. Here a strike-off order was replaced with a 4-month suspension, and the recommendation was that psychological support was offered in the form of counselling to the registrant to help them recover. This case showed a strike-off order being overturned following a Crown Court acquittal. The registrant was accused of sexual assault by a patient, and this was always denied by him. Mr. Ogo had been charged by prosecutors with penetration and sexual assault of a patient, but he was found not guilty by a jury at Luton Crown Court. However, he was then struck off by the NMC panel. The judge sent the case back to the new panel, who then found no impairment. In the case of Laura Hindle versus the NMC in 2025, Judge Alan Bates was highly critical of the NMC's conduct when investigating, also the panel's examination of the evidence and the weight given to live witnesses, the inability to take into account the registrant's 4.5 years of exemplary service since the allegations, and finally the possibility that the nature of the referral could have been vexatious. Now we find that 2 of the registrants involved in this case now face their own fitness to practice referral, following the concerns that were highlighted in the appeal about their conduct. The Professional Standards Authority can take a case to the High Court to appeal if they feel the outcome of a panel has been too lenient. This is done on behalf of the public. The PSA will only appeal if they feel the sanction given by a panel hasn't been harsh enough. Both a member of the public and the NMC themselves can refer the case to the PSA and ask them to take it to appeal. Currently, the PSA will not appeal any sanctions that they feel are too lenient on behalf of a registrant. They will only do so on behalf of the public. The PSA will not take cases to the High Court that they feel have been too severe. The emphasis of that, in order to appeal, falls on the registrant. The PSA will not get involved. In the case of Tashampe in January this year, 2026, Tashampe was given a 9-month suspension at NMC hearing, but the PSA took it to appeal, saying that it was too lenient. This registrant had managed to show good practice in the previous 2 years and lots of remediation, and herself had accepted that a suspension was enough to draw a line in the sand and show the seriousness of the allegations. She had hoped to then continue afterwards and get back to nursing and show that she had put things right. Unfortunately, the PSA took it to the High Court, and the case outcome was that she was finally struck off the register. Another case that the PSA took to the High Court was around a suspension, where it was quashed and remitted to a new panel for a fresh hearing. This concerned areas of serious sexual assault. It is rare for the High Court to intervene when the NMC do applications to extend their 12-month interim extension hearings, but in the case of Richmond, they actually did so. They refused the 12-month interim extension because they said there was no actual credible evidence to show that the case should continue to have an interim order placed on it. The NMC argued that it was in the public interest to do so, but the court stated that that was not alone sufficient to warrant taking the registrant out of practice when the investigation hadn't shown any credible evidence to date. In the case of Ibrahim versus the NMC in November 2025, full findings, misconduct, impairment and sanction were all quashed. It found that the panel had ignored reflective pieces presented by the registrant and had overemphasised that the registrant had a lack of insight. The judge also refused to send the matter back to a new panel, stating that the NMC had severe backlog of cases and this wouldn't be in the registrant's or the public's interest to do so. October 2024 saw a case represented by the RCN where the High Court quashed the striking off order, replacing it with a 12-month suspension, stating that that was more appropriate. The registrant had an interim suspension order that had been placed on the 5th of June 2024 for 18 months, but claimed that this was excessive as a case was due to be heard in November. The NMC conceded that 12 months was sufficient. So what have these High Court cases shown us? Well, there's many themes that run throughout. Let's have a look at them. Excessive and disproportionate sanctions were found in 4 of the cases we looked at, spanning from 2016 through to 2024. The cases are listed here, and you can look them up to find out more information. The aspect of flawed reliance on hearsay and poor evidence handling was also highlighted in a number of these appeal cases. We found that over-reliance on hearsay and poor evidence handling applied to Green 2025, El Kharout 2019 and Hindle 2025. The next aspect is the NMC failing to give good enough reasoning for their decision-making and an inadequate explanation of how they reach those decisions. Poor reasoning and inadequate explanation was highlighted by appeal judges in Lusinga 2017, Waters 2017 and Duthie 2012. Failure to consider mitigation remediation, context, or interim order times was also an aspect that threaded through some of these cases. The judges in these cases highlighted that the NMC failed to consider mitigation and failed to appreciate fully the remediation that the registrants had made. Hindle 2025, Nourish 2026, Hindmarsh 2016, and Camberova 2016. The aspect of there being a potential for vexatious and retaliatory referrals to the NMC has been long discussed, and some of these appeal outcomes are showing this theme as well. In the cases of Hindle 2025, McDade 2013 and Hayward 2009, we found evidence and narrative from the judges to suggest that they felt vexatious or retaliatory factors played a part in these referrals and were failed to be picked up on by the NMC. And finally, there seems to be a failure to consider the use of agreed removal. The NMC are actually reviewing this, and they reassure us that they're trying to look at agreed removal as a potential useful tool in helping close cases for registrants. However, we still support many registrants who have asked the NMC for agreed removal, been able to provide considerable evidence to show them that they are not going to be continuing in the profession nor wish to continue in the profession. But the NMC feel that pursuing to a hearing is appropriate because of the public interest and because of the need to have the case heard. As previously discussed, this has been highlighted, particularly in Hannigan 2025. She tried to apply for agreed removal prior to her hearing, and it was not allowed. She had the hearing, she had an outcome she didn't agree with. She went to appeal, utilising a private lawyer, and the judge agreed with what she said, but also said that she should be allowed to do agreed removal rather than it going back to a new panel. She has been able to demonstrate to the NMC that she's carved a separate career to nursing now, and she merely wants it to be ended. To date, the NMC have not come back to her with a decision on agreed removal, despite what the judge has said. Cost is an important factor to consider when thinking about going to appeal at the High Court, but costs aren't just financial. They're not only the psychological and professional cost to the registrants, they're also loss of earnings which can never be reclaimed and reputational damage which may never be recovered from. But it's also the additional issue of spending registrants' fees on these cases when these cases' outcomes are being shown to be inappropriate or wrong by the High Courts. Registrants' annual fees fund this process, and yet there is no consequence when the monies spent are wasted by a process that simply got it wrong. Is this ultimately the causation? There is no real impact to those that are making the mistakes. The pattern is shown over more than 15 years now. This is not a new story. It is not something that is in the NMC's past and is not historic. It is a build-up of evidence showing that the process itself is fundamentally flawed and there are no direct consequences for errors other than consequences to those who are being regulated. Kat El-Kharout visited the High Court twice, first of all in 2019 and then again in 2020. Her strike-off order was quashed, and there was strong criticism of reliance on hearsay and how the investigation was conducted. It took going back to the High Court a second time to be able to resolve these matters, and Kat herself is still not back in the profession. Jacqueline Daly in 2018 represented herself and took the case to the High Court after strike-off. It was replaced with the conditions of practice. What a difference. This case in 2016 showed a strike-off order being reviewed by the High Court. It was replaced by a 12-month suspension order, again a sanction that was not punitive for this registrant. We have found multiple cases between 2012 and 2015 where strike-off orders have been replaced or quashed in completion, and impairment findings have been overturned. Many of these cases have involved a whistleblowing context, delayed justice following criminal prosecution and acquittal, and human rights issues. Hayward, Jenkinson, Johnson and Maggs are but a few. So from 2009 to 2026, the present day, the same errors seem to be appearing through the courts when the appeals are heard. So why does this pattern persist? The courts tell us of systemic issues. Firstly, the over-reliance on hearsay, and secondly, weak evidence is accepted rather than proven. Many registrants will spend time after the allegations putting things right, and yet the NMC may ignore that good practice. This needs to change. Remediation has been shown to be undervalued by the High Courts, and many judges have commented on this. There seems to be a rigid way of approaching dishonesty charges, and dishonesty still seems to be used as an easy way to win a case. And yet many judges have commented on this and shown that the NMC need to tighten up how they use dishonesty charges. Insight evidence is not being applied correctly, and there seems to be equally an inflexible approach to looking at the registrant's insight. It is encouraging that the NMC may be looking to agreed removal as a way of resolving some cases earlier, but it is worrying that this has not been explored before now. Agreed removal currently is underused. It is a proportionate alternative to going through costly hearings and elongating a referral process, particularly when a registrant has no intention of returning to practice. There is a heavy ongoing backlog of cases with the NMC. Remittal to new panels is an impractical solution. There needs to be a better way. The NMC still has no policy on how to deal or recognise vexatious referrals, and yet there have been many High Court appeals now which show that there may be a vexatious nature to that referral. There are gaps in the current safeguard measures, and this aspect is not taken seriously by our regulator. There is significant human and financial cost to registrants with very limited regulator accountability. Despite High Court scrutiny repeatedly exposing the same errors continue to occur. Poor evidence handling, poor reasoning, poor proportionality, and a failure to actually account for the individual decision making. As a nurse or a midwife, very few of you will consider appealing if you don't have the support of your union. However, through tracking these cases, we've seen that the High Court judges are sympathetic and will try and help where they can. Litigants in persons and unions do overturn findings and sanctions, but we need more to do so in order for the NMC to really take account of the mistakes they keep repeating. By sanctioning the wrong registrants or sanctioning registrants in the wrong way, the public interest is sidelined. The pattern of these cases is not old news. These are not cases that all sit in the past of an NMC that did things differently a few years ago. Many of these cases, 11 in total, have occurred in the last year. The consequence of this is a loss of experienced nurses, damage to confidence in the profession and the regulator, and there is a need for reform in order to review why these mistakes keep happening and how proper change can occur to stop them being repeated. These cases demonstrate that the regulator far too often prioritises process and severity over fairness, evidence, quality of that evidence, and proportionate outcomes. Courts continue to correct the NMC at significant cost to the registrants and the public purse. Further scrutiny and systemic change remains necessary. By looking at these cases, with High Court judgments spanning from 2009 to 2026, we see an alarming trend. excessive sanctions, procedural failures, and flawed reasoning. Registrants generally are unable to challenge this due to a lack of finances, poor mental health impacts following protracted procedures, and a general lack of knowledge of the legal system.
Heartbreak.
From quashing unjust rulings for veteran nurses who've had years and decades of experience in the profession, to exposing systemic flaws in evidence handling, the courts have voiced their concerns loud and clear. These repetitive mistakes lead to the loss of experienced nurses, fail to prosecute those registrants who may be causing harm, and erode public confidence in the NMC.
It's time for change. Biceps.
Please join the conversation. Help support us so that we continue to push for better. Speak to your MP about the need for fairer policies, more accountability, and a focus on evidence-based outcomes in the nursing profession. Demand better from your regulator.